And welcome back. So Blind SA is taking the Institute of Certified Bookkeepers to the Equality Court, accusing it of discrimination against the visually impaired students. The case involves 50 volunteer treasurers from Blind SA who are struggling to complete a national certificate in small business and financial management. And this is due to the ICB's refusal to adapt its online platform. Represented by Section 27, Blind SA argues that the students have been left stranded. The case will be heard today. The president of Blind South Africa, Christo de Klerk, now joins us live. Christo, very good morning to you. Thank you so much for making time for us. Tell us about why you've launched this particular case. And since the conversation had started with Blind SA and Section 27 and the ICB, what was their take on why they have not adapted the system?
Good morning to you and to the viewers, and thank you for the opportunity. Yes, I suppose they have had their online platforms developed without even considering that blind persons might need it. Now, when a blind person uses a computer, we use what is called screen reading software, which describes through synthesized speech what is going on the screen, which controls are active, that sort of thing, what the text is, and everything you might need to interact with the computer. Now, many computer systems are not born accessible. They've got to be made accessible, or they've got to be made accessible from the beginning, which is by far the cheapest option. You may have many graphics on the screen that are not described, or just a link that says click here without saying what would happen if you click there. Would it self-destruct or what? You don't know. So those matters need to be taken into consideration when a website is developed. Now, when we embarked on this training, we asked them if their systems are developed, and they said that they do provide for people with visual impairments. We wanted to have a look at their systems to check if it would be accessible. They absolutely refused that and said they would do it themselves. We explained that if you're not a screen reader user, if you're a mouse user, not a keyboard user, you would not be able to do that. But they said they would. And then they ran some software on it which checks for accessibility, and it pointed out some accessibility issues. So they said, sorry, their system is not accessible. We asked for an alternative method for writing the exams. Up until recently, they used to have a paper-based exam. We asked for that. They would not engage with that. They deregistered our students and said, sorry, they cannot accommodate. So we felt that was discrimination. Their software should have been accessible, or they should have had an accessible alternative in the place of it. And that is why we have then launched the urgent application against them to accommodate our learners.
Yeah. So when, for instance, we speak about the non-visual desktop access software, is there any indication why the ICB has decided not to adopt this?
They said to make their software accessible now would take too long and would be too expensive. They would not have had their problem had they taken the steps from the start to have it developed accessible. But anyway, that was the reason they've given. Why they would not accommodate us in any alternative way, like the paper-based exam, I have absolutely no idea.
Yeah.
So we sorry?
No,
yes?
You can go ahead.
So we've launched the application, and it serves today, but thank goodness they've come to their senses and they are settling this out of court now. And they are actually entering into an agreement with us now where they are giving us what we've asked from the very beginning. So I don't know why they even bothered to oppose this and let it go all this way. So what we are agreeing now is that learners can do they got a choice of doing the online exams or doing the paper-based exam with a scribe or an assistant of their choice. And that will then be made an order of court today. So we are mightily relieved that they came to their senses.
Okay, so this is an out-of-court settlement, but there's going to be an order to certify at least that this is the agreement that has been reached between the parties. But what happens to the non-visual desktop access software? Because it sounds to me that they are saying that, okay, let's go the alternative route, which is a paper-based, and like you said now, also the other one being having an assistant. But what happens to the non-visual desktop access software?
The non-visual desktop access, or NVDA as we call it, that is the screen reading software used by a blind person to describe the screen.
Yeah.
So that will be on a computer. That can still be used. We don't know the software might even be quite accessible. We don't know. The first prize would be if the candidate can use NVDA to access the screen. But if that is a problem, they can use an assistant of their choice to describe the screen to them instead of NVDA describing the screen to them.
Yeah. The other part around this is also when we look at the other examination boards, for instance, if you look at SAICA, do we know whether they use the non-visual desktop access software?
I don't know them specifically, but many places do and others do not. In the United States, they have the Disability Act, the ADA, which compels organizations to make their websites accessible. So American websites in general are perfectly accessible. We have a big issue here in this country, and Blind SA's Advocacy Committee is working on that. We, for example, have a huge issue with banking platforms not being accessible, and we've been all over. We've been to the Human Rights Commission. We are looking at litigation as far as that concerned, also because doing your banking is probably the most confidential work any person can do, and not to be able to do that on your own, we feel is also discrimination. So we have this accessibility issue all around.
Yeah. So what then happens to the test of discrimination? Because if you have an out-of-court settlement, the court wouldn't necessarily then deal with the argument that Blind SA in Section 27 has put forward, that this decision that was taken by the ICB essentially amounts to discrimination. Because I believe that should be a test as well that is settled, so that we almost have a standardized industry approach.
Yes, we were hoping we would get that. That would set a precedent. But our first consideration is to get our students to get their qualification as soon as possible. We will fight the fight in parallel because we need that. The court will also, part of the settlement is that they will make their software accessible. They will do it in a phased approach, starting within the next 3 months. So that is included in the court order.
Okay. Just a quick final one, and this is also relating to people with who are visually impaired. The Copyright Amendment Bill that has still not been signed into law, even after that Constitutional Court order. For Blind SA, what's the next step here?
Well, this is news so hot off the press that I'm not quite sure whether I'm even entitled to mention it yet, but let me do it anyway. On Friday, we've lodged an urgent application in the Court to compel the president to do his work. We hope to get the case number and the lodging registration from the Court today, but the case was served on the president.
Yeah. So the matter has been served on the president. Has there been any responses yet from the presidency?
No, nothing at all. Does he ever respond to anything?
Yeah. In conclusion, on that part as well, with the absence of signing the Copyright Amendment Bill into law, how does that affect people who are visually impaired?
Well, in two ways, really. The ghastlier of the two ways is that the interim relief granted by the Concord 2 years ago has now lapsed. That read in an article into the old Act to give it constitutionality and to allow access to blind persons without having to grovel before publishers for permission to make books accessible. That has now lapsed. And the other thing, we need the president to sign the bills into law so that government has the legal framework to ratify the Marrakesh Treaty, which will then allow international access to books in other countries where there are many, many, many books, hundreds of thousands of books more, which are already in accessible format. And we do not currently have access to them, and that will then give us. So it is of vital importance that he must do his work and sign the bill into law, get on with ratifying
and it's been,
Marrakesh.
11 years now since we've signed
It's 11 years.
Marrakesh Treaty. Thank you so much for your time.